check the back real quick? I think that'll work better. Okay, let's go ahead and get started. Welcome, everyone. Before we start, though, can I remind you to silence your chirping, squawking, talking devices? Double check mine. I am Glenn Moots, professor here at Northwood and director of the university's Forum for Citizenship and Enterprise. And I'm very happy to see you tonight, especially since I'm competing with a warm October evening, which is a rarity, so I appreciate you coming out. And I want to welcome you to our second event of the fall semester. If you'd like me to send you an email reminder of upcoming events, there's a sign-up sheet on the glass table right behind the audio-video booth here. Just go ahead and put your name and email on there, and I'll put you on the list and remind you of our upcoming activities. I'll tell you about the next two activities right now. On Tuesday, October 24th, we will have a panel of scholars, same format, on the question, is Islam compatible with a free society? And I've got some really fantastic people for that. I really encourage you to come out for that. It's going to be a great event. On Thursday, November 16th, we'll host a debate on the question, did the founders want an activist government? Now, those events are going to be in here, 7 o'clock, so same room, same time. Also, I want to acknowledge our co-sponsors for our semester's program, the Institute for Humane Studies, the John Templeton Foundation, and also the Charles Koch Foundation. Now, the Institute for Humane Studies and the Koch Foundation are both very interested in supporting you, our undergraduates, in your continuing education, whether that is summer programs or graduate school. So if you're interested in those things, please see me, and I can let you know about those opportunities. Well, some of you may recall that recently we had Freedom Week here on our campus. And if you were to ask educated Americans or people around the world who consider themselves admirers of the United States, they will tell you likely that the greatest freedoms are enshrined in our Bill of Rights. And the first of these rights are found in the first of the amendments, which reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or of the right of the people to peaceably assemble and to petition the government for a redress of grievances. In law, we call these civil liberties, rights and freedoms guaranteed in our Constitution. This evening, we gathered to consider the status of those liberties with the expertise of scholars who specialize in these questions, and the occasion of our gathering is the multitude of controversies that now seem to threaten these liberties. We'll consider these matters as a panel. Each of the panelists will speak to the questions of speech and religion for about 20 to 25 minutes here from the podium, and then our moderator will ask questions of them and also take questions from you, the audience. This will enable the panelists to engage with one another and also with you in the remainder of our time. And as our panelists speak, our moderator will introduce them, but I want to now introduce our moderator here on my right. Professor Ben Kleinerman is Associate Professor of Constitutional Democracy at James Madison College at Michigan State University. Professor Kleinerman received his Bachelor of Arts at Kenyon College in Political Science and his PhD at Michigan State in Political Science. He is a former postdoctoral fellow in the Program on Constitutional Government and a former visiting fellow in the James Madison program at Princeton University. His research currently focuses on the relationship between executive power and constitutional order. He has published articles in a variety of journals and edited collections, and is author of The Discretionary President, the Promise and Peril of Executive Power. He has also been invited to speak at a number of campuses, including Yale, Notre Dame, and Kenyon, and he was also here on our campus, I want to say 2 or 3 years ago, to speak for Constitution Day. Professor Kleinerman is currently working on a second book, the continuing investigation into executive power, currently titled Becoming Commander-in-Chief, a Constitutional Success Story. Professor Kleinerman teaches on both political thought and political institutions. With that, please join me in welcoming our panel.
So I want to begin by thanking Professor Moots for having me here, especially because my only real role seems to be to introduce people. First then, Darren Guerra is the chair of the Political Science Department and Associate Professor of Political Science at Biola University in La Miranda, California. His scholarly focus is on American politics, constitutional law, and public policy. His book, Perfecting the Constitution, The Case for the Article 5 Amendment Process, was released in 2013. Guerra earned his doctorate from Claremont Graduate University. While at Claremont, Darren served in the California state government as a member of the California Student Aid Commission and the Post-Secondary Education Commission. He has done public speaking on a variety of topics, including civil discourse, elections, public policy issues, and was a featured speaker at the Reagan Symposium at Regent University, and has appeared on NPR and Voice of America. Darren has also published articles in First Things, The Federalist, Public Discourse, and The Weekly Standard. Darren is a lifelong Los Angeles Dodger fan, believes that actor Jimmy Stewart was one of the greatest Americans of his generation, and he lives with his wife Catherine and 2 daughters in Southern California. Join me in welcoming Darren.
Good evening. I'd forgotten I'd put the Jimmy Stewart thing in there, but Jimmy Stewart essentially volunteered for military service prior to Pearl Harbor, and that says something for someone at the height of their acting career in that day, or any day, I suppose. Well, greetings from California. It's good to be here in Michigan tonight, enjoying your beautiful weather. Locals have told me that it's like this all year round, which is amazing to me, and now I know why Michigan has so many electoral college votes, because of this great weather. I'm also a big college football fan. Where I come from, USC-UCLA is the big rivalry, but out here, obviously, Michigan State and University of Michigan squared off last weekend. And then, of course, you have the University of Michigan-Ohio State rivalry. Let's give a boo there. ESPN ranked the Michigan-Ohio State rivalry as the #1 sports rivalry in sports, so that's saying something. But I'm glad to be in a good football state, I guess is what I'm trying to say. So anyways, I'm honored to be here tonight. As you know, the title of tonight is Embattled Civil Liberties, Speech, Religion, and the First Amendment. And for my part of the panel, I'm going to focus and highlight a very important case pending before the Supreme Court. And I think this case has at least the potential to dramatically alter the course of constitutional law, at least surrounding the First Amendment in a couple areas. And perhaps by extension, the case has the potential to shape how we interact with each other in civil society. The case I'm referring to is called Masterpiece Cake Shop versus the Colorado Civil Rights Commission. And I'll get into that in a little bit here, but essentially it involves issues of freedom of speech, freedom of religion, discrimination, and public accommodation. And what I'd like to do is unpack some of the facts of the case, some of the issues that arise out of the case, give a sketch of the arguments on either side of it, and at last I'll draw some very brief observations for you to ponder as you consider the larger issues that we're going to talk about here tonight. And this case will be decided in the spring or the summer this year, so if you take some good notes, you can kind of follow along when the media attention ramps up next year. I was going to read the text of the First Amendment, but Professor Moots has done that, so that's good. It's out there. And before getting to the case itself, I want to say a few words about a key distinction I think needs to be made when we're talking about constitutional cases and constitutional issues. And this distinction is noticing a difference between something being constitutional and something being good or bad public policy. These are two very different things. The fact of the matter is the Constitution does not forbid every bad idea from becoming law. In other words, the Constitution may allow many bad ideas to become laws. And the point here is that the Constitution sets general boundaries within which we as citizens are free to debate and decide for ourselves which course to take. The Constitution demands that we're active citizens engaged in our communities and helping think through and support good laws. Now, generally, I find the media is not really good at maintaining this distinction, and often media coverage conflates whether something's a good idea and whether it's constitutional, and they tend to think bad ideas are unconstitutional and good ideas are constitutional. But I just want to kind of set that ground rule tonight in terms of we need to think clearly about those. Most of what I'm going to talk about is kind of constitutional analysis. At the end, I'll kind of challenge you to think about how we as a society might think about these things in a policy realm. Along with that, so the court's job is not to fix all of our social ills, right? And in fact, often when the court tries to fix all of our social ills, it does a bad job of it. There might be some exceptions to that, but in general, I would say that's the case. Okay, so let's look at Masterpiece Cake Shop that's before the Supreme Court. I'll also note, before I get into the facts, this case does involve the issue of gay marriage, and that's a worthy topic to talk about and debate in society. But I would encourage you all to not get distracted by that substance of the case. Try to focus on the more general issues of public accommodation, freedom of speech, freedom of religion, and often in constitutional law, the substance of the case, while interesting and perhaps important, often can distract us from the principled arguments being made and the precedents that are being set in any given case. Rather than gay marriage, the case could have involved any number of other social issues. It could have been drug use or racial issues or dietary issues. It could be any number of things that the same principles would be in play. Okay, so let's get to the facts of the case. In July 2012, same-sex couple Charlie Craig and Dave Mullins from Colorado made plans to legally be wed in Massachusetts and return to Colorado to celebrate with family and friends. Gay marriage was not legal in Colorado at the time. Craig and Mullins visited Masterpiece Cake Shop in Denver to order a custom wedding cake for their return celebration. Masterpiece's owner, Jack Phillips, who was a Christian, refused to design and decorate the cake on the basis of it going against his religious faith. While he did offer to sell them a cake, he said he could not design the cake for them. Instead, Craig and Mullins found another bakery to provide them with a cake. Later, Craig and Mullins decided to file a complaint with the Colorado Civil Rights Commission. And under the state's Public Accommodation Law, the Colorado Anti-Discrimination Act, which prohibits businesses open to the public from discriminating against their customers on the basis of race, religion, gender, or sexual orientation. Craig and Mullins' complaint resulted in a lawsuit. The case was decided in favor of the plaintiffs, Craig and Mullins, and the cake shop was ordered not only to provide cakes, but to change its company policies, provide comprehensive staff training regarding public accommodations, and provide quarterly reports for the next 2 years regarding steps it had to take, whether it's in compliance with the public law. Masterpiece Cake Shop then appealed the decision and refused to comply with the state's order, instead opting to remove themselves from the wedding cake business altogether. They just removed themselves from that type of business. The state's decision was upheld by the Colorado Supreme Court, and then subsequently has been taken up by the U.S. Supreme Court. So now these facts are interesting for a variety of reasons. First, it involves the issue of free speech, since Jack Phillips, the owner of Masterpiece Cake Shop, asserts his right to, quote-unquote, express himself through his art the way he chooses. He considers himself an artist designing these cakes. Second, it involves religious free exercise, in that Jack Phillips argues that his faith prevents him from being a party to a wedding that his faith does not recognize. Third, it involves public accommodation laws that are meant to prevent businesses from discriminating against citizens based on certain protected classes. So let's briefly look at each of these claims of Masterpiece Cake Shop on one hand and the Colorado Civil Rights Commission on the other. And we'll start with the public accommodation laws. Colorado's anti-discrimination law bars places of public accommodation, that is businesses that sell to the public, from discriminating, as I said, based on religion, race, and sexual orientation. Thus, public accommodation laws seek to prevent businesses from selling to some customers and not others based on what the state considers factors that are not directly business related. The origins of public accommodation laws go back to the civil rights era, where such laws forced businesses such as hotels and diners and the like to serve people of all races. Okay, so in this case, the Colorado Civil Rights Commission, from their point of view, they argue that Jack Phillips has violated the public accommodation law because he chose not to design a cake for Craig and Mullins for their wedding. And from the commission's point of view, choosing not to design their cake is an act of simple discrimination punishable by the law. From Jack Phillips' perspective on the public accommodation law, he argues that he serves all who comes to his shop. He even offered to sell Craig and Mullins a cake. He wasn't denying them business. In his point of view, he only refused to express himself through his artistry by designing the cake. He didn't want to design it, but he would sell the cake. For Phillips, he believes he complies with the public accommodation law, but he denies that the law can compel him to say things or act in a way that are contrary to his religious beliefs or the way he expresses himself creatively through his art. So a question for you guys to ponder, and a question the Supreme Court is going to ponder, is how far can public accommodation laws reach? Can it force someone to violate their religious beliefs in pursuit of what's generally considered a good thing, is preventing discrimination? Are freedom of expression or religious freedom good enough reasons to exempt someone from the public accommodation law? This is something that the court is going to be considering in this case, and I would challenge you folks to consider these as well. Okay, the second issue here, freedom of speech or expression. So the Masterpiece Cake Shop side of this is that, as Jack Phillips sees it, the commission's ruling violates his right to freedom of expression. Now you might have noticed when Professor Moots read the First Amendment, it mentions freedom of speech. So how come we're talking about expression? Well, following a string of cases, which I don't have time to unpack, the Supreme Court has held that freedom of speech includes freedom of expression. For instance, the court has ruled that actions such as paintings, fiction, music without words, theater, sculpture, stained glass windows, pictures, drawings, engravings, movies, tattoos, and I was reminded by my colleagues, nude dancing has been included by the court as acts of free expression. So far, it's true. So for Phillips, artistic creation of a special design on a wedding cake is a form of expression, and for him should be protected by the First Amendment. For Phillips, then, it follows that if the state of Colorado compels him to create artistic expression that he does not want to express, it is violating his First Amendment rights. In the Supreme Court kind of landscape, there's also a strain of cases called the compelled speech doctrine. Excuse me. In a case called Woolley versus Maynard, the court found, quote, that the First Amendment protects the right of individuals to hold a point of view different from the majority and to refuse to foster an idea they find morally objectionable. Woolley goes on to say that freedom of speech thus includes both the right to speak freely and the right to refrain from speaking at all. Jack Phillips, from his perspective, says he's claiming a right to refrain from speaking. Thus, for Masterpiece Cake Shop, Jack Phillips asserts that he has a right to express himself as an artist in the manner he chooses, and he regularly refuses to do all types of cakes. He refuses regularly to do Halloween cakes. He doesn't do bachelor party cakes he views as obscene. Particular ones, I suppose. Anti-American cakes he won't do. Atheistic cakes he won't do. Racist cakes he won't do. Or anti-family themes he won't design. So he argues that it follows that the state cannot commandeer his talents to decorate a cake for a same-sex wedding if he chooses not to do such cakes. For the state to compel him to design a cake that he chooses not to do is a violation of his free speech. So the question for you and the court is, can the government compel citizens to affirm a belief in which the citizen disagrees? Now, on the other side, the Colorado Civil Rights Commission argues that Phillips' design of a cake is not speech at all. It's conduct. And the state may regulate conduct. They regulate all types of conduct. I could have been pulled over on the freeway today for speeding. That would have been conduct, right? It's not necessarily my expression that I'm expressing there. All business and business products, from the Commission's point of view, are potential vehicles for expression. The state is simply telling business owners that they must offer their products to everyone, and the selling of a product or a service should not be considered speech. In this sense, and in their view, a cake is simply a cake, and it is not an extension of the cake artist's speech. Furthermore, defenders of the Commission's point of view argue that no one, upon seeing the cake, is going to assume that it is representing the views of the artist. Rather, most will assume that it is representing the words or images on the cake are the expression of those who bought the cake, and not the person who made the cake. If no one will associate the expression on the cake with the artist, then the court, the argument goes, should not grant the cake decorating the status of speech. If the cake decorations are not considered speech, then Phillips' creative efforts would not garner the protection of the First Amendment and the protection of freedom of speech that goes with it. So the question for you, and again the court, is where is the line between conduct and speech? Clearly the government can compel right conduct. They do so in any number of ways. But can that conduct be extended to include artistic renderings on commercial products? The other question that follows from this is whose speech is it? The client's speech, the people ordering the cake? Or is it the artist's speech, the artist creating the cake? So that's an issue the court's going to have to decide, and that's one that you guys, I would challenge you to reflect on as well. Okay, the third issue at stake here, freedom of religion. From Jack Phillips' point of view, forcing him to make a cake on an issue that violates his sincerely held religious beliefs violates the Constitution's protection of free exercise of religion. Furthermore, Phillips argues that because the Commission has allowed others to be exempted from the Public Accommodation Law, this Commission is targeting him for his faith. Now, what are these other exemptions? So there's a general public accommodations law, but other businesses have approached the Commission to be exempted from this public accommodation law. So the Commission has exempted the following. It's exempted an African-American cake artist from having to create a white supremacist cake. It exempted an Islamic cake artist from having to create a cake denigrating the Quran. And it exempted 3 secular cake artists from having to create cakes opposing same-sex marriage. So Phillips wonders why the Commission would allow these artists to be exempted from the Public Accommodation Law, but not exempt him. Okay, the Colorado Civil Rights Commission. The Commission argues that they are not prohibiting the free exercise of religion. Rather, they are simply regulating the conduct of citizens. Again, this emphasis on conduct. And business owners not to engage in discrimination. Second, it was brought up that Phillips is free to create signs in his shop or some kind of notice that expresses to his customers that these designs are not expressing his religious views on these things, and that should be enough to signal to the public that he doesn't agree with the views on the cakes that he's designing necessarily. They also assert that the government has a right to generally apply laws to all religious people in a way, and that religion cannot be a shield for discrimination. Okay, I'm going to unpack a little bit about this freedom of religion in terms of how the court normally deals with these things. The court usually applies one of 2 tests here, either strict scrutiny or a rational basis. This last point brings up a key dispute in the Supreme Court doctrine regarding free exercise clause. I'll skip ahead here. So strict scrutiny. A good case to look at to understand this one is a case called Sherbert v. Werner. It involved a Seventh-day Adventist who was prevented from collecting unemployment benefits because she refused to work on Saturdays, and the state said, well, then you can't get unemployment benefits. In that case, the Supreme Court ruled in favor of Sherbert, saying that disallowing her unemployment benefits did violate her free exercise of religion. In essence, the court ruled that religious freedom is very important to American democracy, but it's not an absolute right. And to strike this balance, they came up with this strict scrutiny test. And it has 3 elements. The state has to have a compelling state interest. It has to be something really serious that the state is trying to achieve here. Often the words, the state is trying to achieve something necessary or crucial as opposed to something the state merely prefers, right? Often national security can be an easy example of where lives might be at stake and there's something crucial and the state has to achieve that. That would be a compelling state interest. Second, the law has to be narrowly tailored. In achieving this interest, it can't include a class of people much more broad than necessary. It has to be a narrowly tailored law if they're asking people to go against their religious beliefs. Last, the law has to have a least restrictive means, which means the court asks them, is there another way to do this where you don't have to ask people to violate their religious beliefs? And if there is another way to achieve the same purpose, the court compels the government to choose that other way. Contrast this with the rational basis test. This came to the fore in terms of religious freedom law in a case called Oregon v. Smith. And in Oregon v. Smith, we had American Indians that worked at a drug treatment center, but then used peyote on the weekend as part of a religious ceremony, and they were fired because they were using drugs against Oregon state law and the employment contract. But they said, no, this is our religion. We're not just using drugs recreational. This is part of our religious beliefs. There, the court ruled that, no, we're going to apply a rational basis test, that the government has a right to have laws that apply generally to everyone, and it's not targeting American Indian peyote use, and therefore they have to comply with the law that's generally applicable to everyone. And as long as the government has a rational basis for the law, then it's okay. And they denied those men their jobs. They did not protect their religious freedom in that case. So you have these two tests competing. Hopefully you can see how, depending on which test the Supreme Court applies to this case, will impact their ruling. If the court applies the rational basis test, then the court may find Colorado's public accommodation law is rational and generally applicable, and that Jack Phillips may not be exempted from the law on the basis of his faith. However, if they apply the strict scrutiny test, then Phillips will have a strong case that the government can achieve non-discrimination in a least restrictive way because Craig and Mullins easily found another cake, and in the end they suffered no harm. So hopefully this very brief constitutional analysis helped you think about the ways in which the court might rule based on the Constitution and based on court doctrine as it's developed up to this point. So that just leaves a few public policy questions for us as citizens to ponder. Either way the court rules, going forward, we as citizens, through our city councils, through our state legislatures, through Congress, we have a duty to engage and think about these things carefully. And if Aristotle is right about politics, then politics is essentially how we as a community ought has a moral laden turn, how we ought to order our lives together. So some things to leave you with to think about on this issue in this case. Do we want, as Americans, to continue to respect pluralism and rule of law? In terms of pluralism, can we find a way to create laws that allow persons to get cakes for their weddings without having to compel persons to provide them when they would rather not? I, for one, think we can and should accommodate people's religious beliefs as much as we can, even when we don't agree with them. That's tended to be the American way, that we agree to disagree, even on really, really important things. There is even a debate within Christian communities as to whether or not to provide cakes or flowers. So it's not, see a Christian, they don't provide the cake. Christians debate whether to provide these things, and many Christians will have no problem providing such cakes. However, those who do feel like it's their duty to God to not participate, can we respect their decision? Should the law respect their decision? That's something to think about. That's what pluralism is about, is to have people have very strong views on things, and yet they find a way to live together and move forward as citizens. This type of pluralism allows persons to hold strong but divergent views and yet still live together in community. And that's why I think this case is important for how are we Americans going to think about it in kind of this age where all these kind of deep-seated issues are hotly debated. Another thing to think about is public accommodation laws, and there's a number of ways to think about them. But one way to think about it is public accommodation laws in the market. So I mentioned that public accommodation laws came to fruition during the Civil Rights era in the Jim Crow South. If you were a hotel owner or a diner owner, say in Birmingham, Alabama, and you had no problem renting hotel rooms or serving dinners to anybody of any race, the law in the South prevented you from doing so, right? The law disrupted the normal market mechanisms, right? A business owner looking to make a profit would have a huge market, a huge incentive to provide meals or hotel rooms or what have you to anybody. But the law was disrupting that. The law restricted the market in key ways. So one could argue that something like a public accommodation law was needed to restore the market to its normal operating functions. The question here is, do we have a similar situation? Is the market so disabled that people can't get the services they need? Right? And so this is where we as a society and the court are going to have to balance how much does the state have to intervene in the market in these situations? Or is the problem not as much of an issue and we can accommodate people's beliefs? And one might ask, are the basic substantive issues at stake very different in their nature? That's a whole nother talk. The argument has been made that the way this public accommodation law is being used is kind of weaponizing public accommodation laws to shut down speech or shut down religious views that the state finds objectionable. So that's something to think about. How should public accommodation laws interact with markets? Two last quick points here. In terms of freedom of speech or expression, if the government can coerce Jack to bake a cake, can they coerce you to do or say what they want you to say? Does our freedom of expression depend on a principle that applies as nearly as possible to all, or does it depend on who's in office and who has power? Do those with power simply make the rules that allow them to favor who they wish? Or do those in the minority of views deserve the same protection as those in the majority regardless of who's in power? I think it's to a basic element of politics. Should government's coercive power be tied as closely as possible to principles that are universal and generalizable, or should government's power be tied to whoever controls the levers of power at that given moment? And as Americans, we've tended to favor the former against the latter, but it's a constant human problem to pay attention to. In terms of freedom of religion, I'll just say this, because I think some of my colleagues will expand on this, but can the state trump God? Rights of conscience, such as religious free exercise, or even rights of conscience not rooted in religion, are not simply based, at least rightly understood, they're not simply based on one's personal preference. They're based on one's duty as that person sees it, their duty to God, or to their faith, or if they're not religious, their duty to their conscience. They're not acting out of a willfulness necessarily. They feel bound to God on one hand and then bound to the state on the other, and they're caught in a bind. If the church can be co-opted by the state, then anything can be co-opted by the state. Religious freedom in its origins has protected everyone's freedom, even atheists, even agnostics. From its earliest days in the West, say back as far as Rome, the church has always provided a counterweight to the state. And it has done so in a manner that allows all persons, religious or not, to be free from state coercion in key areas. Thus, I would argue that even non-religious persons, all persons, have an interest in preserving robust religious liberty because it creates space in society for other people to have other associations and preserve their consciences. So in closing briefly, regardless of what the Supreme Court does in this case, and I would encourage you all to pay attention and follow it, I would hope that we as Americans can seek to preserve our system of robust pluralism and rule of law. And this rule of law is embodied by a Constitution, which I would argue its very existence is a testament to the proposition that there are higher authorities than mere majority opinion expressed through government laws. Thanks for listening.
Well, thanks, Professor Guerra, for those enlightening comments. And now I'll turn it over to Jesse Covington. He's the associate professor of political science at Westmont College in Santa Barbara, California, where he teaches and writes in the fields of political theory and constitutional law. He earned a PhD in political science from the University of Notre Dame, an MA in religion at Westminster Theological Seminary, and a BA in political science from Pepperdine University. Dr. Covington's research interests focus on the interrelation of religion and government, particularly as regards First Amendment law, natural law, and the foundations of political liberalism. His writing includes publications on John Locke, St. Augustine, natural law, the First Amendment, and liberal arts education. Dr. Covington is currently working on a book manuscript provisionally titled Taken on Faith, the Concept of Religion in First Amendment Jurisprudence. He is also engaged in an ongoing collaborative project on Protestant political morality. Dr. Covington resides in Santa Barbara, California, with his wife and 4 children. He has taught at Westmont since 2007 and has also held appointments at Princeton University and Wheaton College. So join me in welcoming Professor Covington.
Well, good evening, and thank you for that introduction, and thank you to Professor Moots for the invitation to be here. It's a pleasure to be at Northwood University, and it's very much an honor to be on a panel alongside such distinguished colleagues. Well, Professor Guerra focused on one case in particular, and I'm going to do something much more broad. I'm going to be all over the place. And so this evening I want to talk about the Pledge of Allegiance, about birth control, about God, about totalitarianism, and about James Madison, all in the space of about 20 minutes. So keep your hands and feet inside the ride at all times. Even though I work primarily in the fields of constitutional law and political theory, technically I am located in the division of social sciences, and social scientists like to measure things in society. So we're going to take a couple of quick polls if you're willing to play along. And so when I ask this question, do raise your hand. And actually, if you're wearing a hat, you can raise that so I can really see you. But here's the first question. How many of you think that liberty is important? Okay, good. All right, thank you. Now, how many of you think that religious liberty is important? Okay, good number. Now, this is the last one. So far we're doing pretty well. How many of you think that religious liberty would be most important among the liberties that citizens enjoy? Okay, a significantly smaller number, more than I expected. Nationally, the number's about 10% would say that religious liberty is the most important liberty that citizens enjoy, according to a poll conducted by the First Amendment Center just a couple of years ago. So here's what I plan to do in the next 18 minutes. I'm going to tell 2 stories about the Pledge of Allegiance that help to explore the place of the freedoms of speech, and especially of religion, in relation to liberty more generally. In other words, to demonstrate how the first question that I asked you might be related to the last question that I mentioned. Specifically, I want to examine concerns that some have about privileging religion and highlight some counterintuitive arguments about how religious liberty might undergird liberty more generally. This is particularly relevant at a time when increasing numbers of citizens suspect that First Amendment liberties may actually pose a danger to a liberal political order rather than the other way around. And by the way, just as a side note, I'm going to be using the term liberal in its classical political theory sense, which simply means a limited rights-respecting government rather than something that we might contrast with conservative. Okay, so I said I would tell 2 stories about the Pledge of Allegiance. Here's the first one. The first story about the pledge we might title Getting It Wrong and Then Getting It Right. In the 1930s, the school district of Minersville, Pennsylvania had a policy mandating that all children should salute the flag and say the Pledge of Allegiance at the beginning of each school day. Two young children, a brother and sister, Lillian and William Gabaitis, refused because they believed their religion prohibited venerating an object. They were both expelled from their school for refusing to say the pledge, and the Supreme Court upheld their expulsion in a 1940 case. For those of you who follow the Supreme Court, that was the Gabaitis case. For the rest of you, don't worry about it. And the Supreme Court cited the state's interest in promoting national unity. In other words, the Supreme Court reached the perhaps troubling conclusion that a state can compel unwilling speech and can punish those who do not comply, even for reasons of conscience. Now, most of us can see significant problems with this, as such power is only as good as those who wield it, as Professor Guerra was pointing out at the end of his remarks. And also then the speech that you're compelling quickly becomes meaningless because it's compelled. There are a number of other problems as well. And the Supreme Court quickly realized its error. Just 3 years later, in a case called West Virginia versus Barnett, the Supreme Court struck down a similar regulation and overruled Gabaitis. It was in the Barnett opinion that Justice Jackson penned these famous words, which many of you may have heard before. If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. Say that again, because these are important. If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. In other words, the state should get out of the business of compelling speech, or in this case, the freedom not to speak, like the Maynard case that Professor Guerra noted. Freedom of speech, or the freedom not to speak, supersedes otherwise permissible goods that the state might pursue, like, as in this case, the pursuit of national unity. So far, so good. But what about the closely related freedom of conscience as regards conduct rather than speech? We'll come back to the pledge later, but that's the first story about the pledge. Let's turn to the question of conduct rather than speech. We need look no further than the headlines over the last few days. Let's begin with the contraceptive mandate in the Affordable Care Act. As you may know, the Affordable Care Act, sometimes referred to as Obamacare, requires employers to provide health insurance to employees, including a variety of contraceptive and birth control measures. This provision is commonly known as the contraceptive mandate. This has proved contentious, and thus heavily litigated, indeed all the way to the Supreme Court, because many religious employers object to some or all types of birth control for religious reasons. Among others, Roman Catholicism teaches that contraception is morally wrong and that some forms of birth control are the moral equivalent of homicide. For such groups, a government requirement that they provide birth control functions as a mandate to act against their religious convictions, to commit a moral wrong. Like the cake decoration case, the contraceptive mandate raises questions of when can the government require someone to do something that violates his or her conscience. It's the same kind of scenario as the pledge case, except that here it's more doing than saying. It can't be covered by the freedom of speech, as perhaps the cake decorating case might. Now, to move to what's in the headlines these last few days. Just this past Friday, Attorney General Jeff Sessions announced new guidelines for federal agencies on religious liberty, including offering broad exemptions for religious individuals and organizations when their convictions are at odds with certain types of regulation. In other words, in an effort to protect religious liberty and avoid forcing people to violate their consciences, government should give more deference to religious objections. So consistent with this, the Department of Health and Human Services also issued some new guidelines specifically dealing with the contraceptive mandate. And these said that broadly, we can exempt organizations with a religious or moral objection to birth control from the contraceptive mandate under the Affordable Care Act. a move that actually has the potential to resolve a number of the current cases being litigated in this area. Essentially, this new guideline from the HHS states that religious objections can supersede the goods pursued by the Affordable Care Act. Now, much of the editorial pages treatment of this issue is focused on the politics of all this, and I think the policy issues are actually quite important. For example, you'll see many of them are focusing on access to birth control, etc. And while the issues are important, the policy issues are important, here I'm going to focus less on the politics and more on the legal and theoretical issues that are presented to us in relation to religious liberty. Specifically, I want to probe a bit the apparent privileged position given to religion in this scenario. That is, if you're going to say a religious reason gets you off the hook from obeying a law, isn't that saying religious reasons are better than other reasons? To put it a little bit differently, I think the problem goes something like this. Giving religion a privileged place seems to entail the government picking sides and preferring religion to other views. In other words, it seems to be potentially what we might call establishmentarian, insofar as it prefers religion to non-religion, and thus illiberal, that is, incompatible with liberty-respecting, rights-respecting government. And I want to ask, is this right? Now, even the way that we frame this begs the question of how do we define religion? Because if you're going to give religion special privileges, then you have to deal with the definitional problem. Happy to get into that later in discussion if we want to, but I'm going to try to bracket it for now. Many are convinced that the problem really is a problem, that our constitutional commitment to religious free exercise should be interpreted narrowly, prioritizing non-establishment over free exercise. And I think even going back to that quote that I read twice from the Barnett decision, we can see both potential readings of it. Because on the one hand, Barnett insists that no official can prescribe what shall be orthodox in politics or religion. So it seems, in one sense, that Barnett is saying government should be neutral in some sense. But on the other hand, Barnett itself seems to privilege a sort of orthodoxy of liberty for specific categories, and it singles out religion and speech among those. So can this problem be resolved? Can the problem of privileging religion be resolved? How do we categorize government priority for religious liberty? Is it a failure of neutrality or a triumph of liberty? Well, this brings me to the second story about the Pledge of Allegiance, and this one we might title, When Being Under God Might Be Good for Liberty. And I'll start with an important case reached the Supreme Court in 2004. It's not actually a particularly important case, but I won't go into why not. But the fact basis for the case involved a man named Michael Newdow suing his daughter's school district on behalf of his daughter for including the Pledge of Allegiance at the beginning of each school day. Now, two important changes have taken place since the last pledge story I told. One change is that the Pledge of Allegiance at the beginning of a school day is no longer mandatory. You can't make a kid say it or threaten to expel them if they won't. And the second is that the words "under God" have been added to the pledge. Indeed, it's the words "under God" that Michael Newdow objected to in inviting, though not requiring, his daughter to say the Pledge of Allegiance. The state, he contested, invited her to recite a religious creed of sorts, violating the Establishment Clause. Now, I'm not going to dwell on the details of the case, but on the more theoretical issues that arose as it was being considered. Congress added the words "under God" to the pledge in 1954, and I think we might fairly ask why. Well, the evidence is certainly mixed here. I'm only going to draw out one theme, but one of the important themes was to assert against Soviet communism the secondary nature of the state, what we might call the penultimacy of the state, and the moral limits on government that individual rights entail, especially the sorts of rights that get articulated in the Declaration and the Bill of Rights. I'll explain. The legislative record at the time, if you go back and read dusty old volumes about this stuff, which at one point I did, the legislative record at the time reflects just this sort of concern. The rise of totalitarianism was seen as directly linked to the atheism of communism. That is, the words "under God" were intended to convey the political philosophy of the Declaration of Independence, that all people possess pre-political rights that the state cannot alter. And I'll just give you two quick examples from the time. Consider how Congressman O'Hara of Illinois put it during the debates in the House. He said this: "Our American government is founded on the concept of the individuality and the dignity of the human being. Underlying this concept is the belief that every human being has been created by God and endowed by him with certain inalienable rights which no civil authority may usurp. Thus, the inclusion of God in our Pledge of Allegiance sets at naught the communistic theory that the state takes precedence over the individual and plainly denies the atheistic and materialistic concepts of communism with its attendant subservience of the individual." Now, regardless of whether or not you agree with this argument, that's not the point that I'm trying to make. The point that I'm trying to make is, what did he think he was doing? Likewise, President Eisenhower, when he signed the Pledge Amendment Act into law, said this, that the words under God were, he linked the words under God to morally limited government. He stated that the founders, quote, "recognized God as the author of individual rights, declared the purpose of government is to secure those rights." And then he continues that if the state gives rights, it can and inevitably will take away those rights. So put differently, adding the words under God to the pledge was seen by many as a bulwark for liberalism, for limited rights respecting government more broadly. Well, essentially, at least for our purposes here this evening, in which we're looking at the place of religious liberty in rights respecting government, these arguments point to a realm in which government has no authority, where government yields to prior claims. In the framework I've just outlined, these prior claims would be the realm of religion. And on this telling, the prior obligations of religion are foundational to morally limited government more broadly. In other words, counterintuitively and contrary to Michael Newdow's claim that the inclusion of these words is fundamentally illiberal, key aspects of the historical record suggest certain explicitly liberal motivations and aims. The argument that the prior obligations of religion limit the authority of the state and undergird freedom more generally is by no means novel. It's by no means new in the context of the United States. It's not particularly original of me to observe it even. And while I could point to other examples, before I conclude, I'll just highlight one from the architect of the U.S. Constitution, from James Madison. And I'll point us simply back to his memorial and remonstrance against religious assessments in the state of Virginia. His memorial and remonstrance was simply written to protest a bill that would have taken tax monies and paid clergy with them, essentially. And he saw this as a serious problem. He thought that this was itself illiberal. And he grounds his objection to it, much like the rationales for the pledge that I just pointed to, he grounds these on religion as prior obligation. He puts it this way: what is here a right toward men, religious liberty, is a duty toward the Creator, religion. This duty, that is religion, is precedent both in order of time and degree of obligation to the claims of civil society. And he goes on to insist that this makes religion wholly exempt from government's cognizance. In other words, for Madison, the prior obligations of religion limit the scope of government. The prior obligations of religion limit the scope of government, rather than challenging or undermining the principle of non-establishment. This understanding of religion provides a philosophical foundation for non-establishment. Madison takes this even further, though, and this is really getting to the heart of the question about the relationship between religious liberty and liberty more generally. Madison takes this further and suggests that all limited government is at stake on this very issue. I continue to quote, "The equal right of every citizen to the free exercise of his religion according to the dictates of conscience is held by the same tenure with all our other rights. Either then we must say that the will of the legislature is the only measure of their authority, and that in the plenitude of this authority they may sweep away all our fundamental rights, or that they are bound to leave this particular right untouched and sacred. And we could trace these arguments fruitfully backwards toward the Declaration of Independence or to the political philosophy of John Locke, or we could trace them forward to a lot of the interesting case law of the 20th century. But I don't think that's particularly fruitful here this evening. The main point of noting this line of thought is simply to show how not all accounts of prioritizing religion are establishmentarian or illiberal, but rather that some such accounts instead maintain that the prior obligations of religion serve as a foundation for religious non-establishment arguments and broader moral limits on government as such. Justice Douglas once put this very succinctly when he said, "The institutions of our society are founded on the belief that there is an authority higher than the authority of the state." There is an authority higher than the authority of the state. So to conclude, I want to be sure to be clear on what I have not tried to do here. I have not made the case that a prior obligation argument, that is, a prior obligation foundation for morally limited government is true, or even that it's the best argument for limited government. That would be a different sort of presentation and indeed inquiry. Rather, I've tried to make a case that a strong governmental commitment to religious liberty, even prioritizing religion over otherwise permissible goods, is not necessarily establishmentarian or illiberal. Instead, and quite the contrary, I've sketched out a significant strand of American liberalism in which the priority of religion as an obligation prior to and superseding other claims serves as a basis for morally limited rights-respecting government more generally, and at a time when roughly 10% of Americans identify religious liberty as the most important liberty, and roughly half of Americans think government should compel citizens to violate their religious beliefs when other goods are at stake. At a time when those things are true, I think this warrants attention. Devaluing or dismissing religious liberty or interpreting it in ways that would exclude a Madisonian account of political liberalism may have unintended consequences for liberty and should be taken seriously, particularly given the historically central role of religion as prior obligation in limiting the scope of government. Thank you.
Thank you, Professor Covington. I now introduce Professor Watson, who's a native of the Golden State of California. God, we have a lot of Californians. Maybe that's why it's so nice here. And completed his undergraduate degree at UC Davis. He earned his MA degree in Church State Studies at Baylor University in Waco, Texas, and holds an MA and PhD in politics from Princeton University. Professor Watson joined the faculty at Calvin College in the fall of 2015. He was also selected to serve as the William Spolhoff Teacher Scholar Chair from 2015 to 2017. Professor Watson's research agenda includes ongoing projects on John Locke, a co-authored book on the political thought of C.S. Lewis, and a collaborative effort with his political theory counterparts at Wheaton and Westmont to consider the possibility of an evangelical tradition of political thought. Professor Watson's hobbies include basketball, long road trips, rooting for the Pac-12.
Sorry.
It's a weaker conference. Pretending to be a film critic, and sled run design. What is that?
Designing good sled run.
Okay.
Why I moved to Michigan.
He and his wife Julie have 4 daughters and a son, Abigail, Anastasia, Annika, Alexandra, and John. Accompanied by their decidedly non-pacifist cats, the Watsons make their home in Grand Rapids, Michigan. Join me in welcoming.
All right, thank you very much. For those of you for whom this subject, you love it, you're glad you're here tonight, You got one more. For those of you who it may not be your first love, you're 2/3 of the way done. So good news for both camps. I am delighted to be here tonight. I think I met Professor Moots about 10 years ago. It's been a while, and was impressed with him back then and impressed by all the things he's been doing. And having spent time at Princeton and some other places that pride themselves on having really good events and bringing in good people, you may not know, but and I'm not saying this about necessarily our panel, it sounds very self-serving, but Professor Moots has done a remarkable job bringing in people the years that he's been here. So you have a real gift, a real treasure to have Professor Moots here. I just want to say that for the camera and for the record. Get that off my chest. He's a great representative of your state and your school, so much so that my family, we had to move to Michigan 2 years ago. So if Professor Covington went even broader than Professor Guerra, I'm going to go broader still. I'm going to go to a 20,000-foot vantage point to talk about the Constitution and the First Amendment. And I'm going to ask some questions, and they may come across to you as un-American. I'm going to risk sounding un-American, so I'm very aware of the flag over there and might get in trouble. Well, while my colleagues have made some good arguments for the importance of religious liberty and freedom of speech and expression, I want us to back up and look at our Constitution from an entirely different perspective, perhaps even a dangerous perspective from a patriotic point of view. Now, I want to warn you in advance, I'm going to ask more questions than provide answers. So if you're left at the end bugged because I'm not getting a lot of answers, then at least you have been warned. Here's my question. What if it's done? What if the Constitution is no longer capable of doing the job it was tasked with doing? Why shouldn't we say that it had a good 230-year run, but it's now showing its age, and we need something new? What if it cannot protect the liberties that we find important, speech and religion and other liberties? What if we don't think those liberties are as important as the founders did? While this may sound un-American, let me make the case for why thinking these questions should be asked is quintessentially American. We have to remember that the American political project is an experiment. Alexander Hamilton, I was a fan before the play, although I love the play too, he opens up the first Federalist paper by noting, "It seems reserved to the people of this country to decide by their conduct and example the important question whether societies of men are really capable or not of establishing good government from reflection and choice, or whether they are forever destined to depend for their political constitutions on accident and force." Now, we now today see the Federalist Papers as one of, if not the, most authoritative commentary on what the original Constitution meant to the founding generation, and that's appropriate. But of course, it wasn't written for that purpose then. It was written as a sales pitch. The Federalist Papers were written as a sales pitch. It assumed, the Federalist Papers, the authors, that the people reading them in newspapers would sit in judgment. Hamilton and his co-authors believed that people back then could establish good government by reflection and choice rather than accident and force. The early Americans sat in judgment of the Constitution, and after a series of debates decided to give it their approval. Can we sit in judgment as well? Consider the approach of another important student of the Constitution. 3 months before the outbreak of the Civil War in January of 1861, Abraham Lincoln was wrestling with how to reconcile the restraints imposed by our Constitution with the philosophy for which the Constitution was the means of achievement. Lincoln wrote in a fragment just for himself, he didn't publish it, he was thinking out things himself, that philosophy, even more than the Constitution itself, was something that, quote, was entwining itself more closely about the human heart. That philosophy is, he said, the principle of liberty to all, the principle that clears the path for all, gives hope to all, and by consequence, enterprise and industry to all, end quote. Lincoln went on to note that the principle was expressed in the Declaration of Independence. And he said that it was the word fitly spoken which proved an apple of gold to us. The Union and the Constitution he called the picture of silver, subsequently framed about it. The picture was made not to conceal or destroy the apple, but to adorn and preserve it. The picture was made for the apple, not the apple for the picture. He's borrowing here a verse from the King James Version of the Bible. It says, "A word fitly spoken is like apples of gold and pictures of silver." In other words, the heart is liberty for all. Religious liberty, free speech liberty, all the liberties in the First Amendment and in the Bill of Rights. That's the liberty that matters. The Constitution is the frame that makes it possible. In other words, Lincoln reminds us that the Constitution, as important as it is a means to a greater end, not an end in itself. And that greater end is liberty for all, relying on the Declaration's lofty claim that all are created equal, and going on to say that this principle is for all, gives hope to all, and even enterprise and industry for all. Means need to be tested, and they're tested by how well they achieve that end. In these two passages from Hamilton and Lincoln, we see what was so different about the American political order and remains different about it in the world today. For unlike the vast majority of nations, our country was not founded primarily on a shared bloodline or an exclusive religion or on claims to an ancestral homeland. Most countries are, the glue that holds them together is a common religion, per se, or a common blood, or an attachment to the soil. That's why in some of the odious movements we have in our politics today, you hear the blood and soil movement. That's a white power type way of talking what a nation should be, right? On the contrary, our political tradition was based on a set of ideas, in principle available to anyone. Hamilton's call for reflection and choice must mean ideas to reflect on and choose. And we have never, now the truth is, that was the theory. Of course, we never, and we still have not achieved that in practice. The ideals expressed in our founding documents were ideals, and the American story can be told as a way of trying to realize those ideals in practice, which were just restricted to white men owning property in the very beginning. Nevertheless, it remains the case that the grounding for the American political experiment is different. An immigrant from Japan or India or Mexico can become a full-fledged American in a much more profound sense, not necessarily without struggles or with discrimination, but can become seen as an American much more than I could, as a 6'8" white guy, ever be accepted as a real Japanese guy or a real Mexican citizen or an Indian. It doesn't work very well going the other way. It'd be a little awkward. It's true, if it's true, that the American political tradition was built upon certain ideas, and if it's true that these ideas have consequences, then the truth or self-evidence of these ideas remain a live issue for us today. We should think of ourselves as included in Hamilton's audience. We too must decide by our conduct and example, by reflection and choice, if our Constitution is working. So why might we think the Constitution is done? Why might we think it's time for something else? There are several people who have made this argument. I won't go into all of them. I want to highlight one particular figure who makes this argument. And in the field of political science, he's a big name. Chances are, unless you're really into that field, you haven't heard of him. His name is Robert Dahl. He was at Yale University for a long time. And the basic idea is that we have really big, complicated problems that need dealing with, and our Constitution still has some rather pesky, restrictive features that tie the president's hand. Dahl says, as wise as the framers were, they were necessarily limited by their profound ignorance, end quote. Now he goes on to say, I write this with no disrespect, which of course, any time someone says that, you know there's a little bit of disrespect. So don't ever believe that. But that's what he basically says, and he goes on to make his argument. To get what is really behind this argument, though, I think it's helped me at least to look at a metaphor. This little data, and how many of you have seen the HBO John Adams miniseries? Okay, it's a handful of you have seen this miniseries. Well, a couple scenes in there that were eye-opening to me. One is, I never knew as a kid what it really meant to be tarred and feathered, and you'll get to see that if you watch that miniseries, and it's pretty memorable. But the other scene that I want to mention is when John Adams is away and there's an epidemic with smallpox, and Abigail Adams is going to get inoculated with her kids, and the doctor comes and he has in the back of his wagon a fellow who's dying of smallpox, and he's just covered with pustules, and it's just really, I won't tell you too much about it after dinner, but what he does, and he makes cuts in Abigail and each of her kids and takes a little bit of the blood from the guy who's dying and basically puts it into them to get them inoculated. It's a stomach-churning scene, and it actually worked. It did work for them. It didn't work for Jonathan Edwards of Princeton University. He did it to show his faculty that it would work, and it ended up killing him. So it wasn't foolproof, but the scene is quite jarring. Imagine, though, if you had to go back in time knowing what you know now about medicine and had to live with 18th century medicine. There was no sterilization, doctors didn't wash their hands, no anesthesia. Imagine being bled in order to fight a fever. As brilliant as some of the doctors were in the late 1700s, we certainly wouldn't want their sort of medicine practiced on us today. And this brings us back to Dahl's criticism of the Constitution. Why shouldn't we think the same thing about 18th century governance as we do about late 18th century medication or medicine? Dahl likens the accomplishments of the founders to the genius of Leonardo da Vinci's inventions, Benjamin Franklin's tinkering with electricity, and the Wright brothers' airplane. As brilliant as they were, Dahl says, we all want our electricians to know a lot more about electricity than Benjamin Franklin, and we would not get in an airplane made with 1903 technology. So of course, in 2017, it's ridiculous to think that the ideals and framework from 1776 and 1789 would still be reliable given the advances we've made in the meantime. We shouldn't expect this at the time brilliant but now creaky old thing to still be working for us. Maybe we should rethink even our civil liberties. How do we answer Dahl's question? How do we think about whether the Constitution still works? Well, one way to think about this is to ask ourselves, what do it mean to craft another one? What if we made everyone in this room a new set of founding mothers and founding fathers tasked with creating a new Constitution? Well, the first thing we would need to do is figure out what constitutions actually do. What do? They do a number of things, but I want to focus on three, and I'll move through this quickly. First, constitutions express the vision of what a political community aspires to and reveals an underlying view of human nature. Lincoln described this as an aspiration for liberty for all. Whether they say these things outright or reflected in how things are set up, every constitution has some kind of vision of the good life that it is trying to make possible. Second, constitutions allocate power by authorizing various political entities at varying levels to exercise that power. They also limit power. They codify at the highest political level what government office or structure decides what, how that office is filled, and how the relationships between the different political actors are defined. Finally, and somewhat paradoxically, constitutions are comprised of laws that create the ways that we make new laws. It's laws making laws. Many constitutions delineate the means by which we work out regular politics, so votes in Congress, right, votes at the state level. And they also talk about how we do super politics, constitutional amendments, those sorts of things that change the very nature of our social contract. Let's get through this. Now, so you've been tasked with this idea. You may have some things that you would like to put into a new constitution. I'd like more room for tall guys on airplanes. You might have your particular priorities that you would like to see put into the new Constitution. But here's the trick. You have to come up with something that can be agreed upon by not only the majority of folks in this room, but by everybody at home that you have to go back and report to whom you're representing. What is the vision of the political community that you aspire to? What does the good life look like such that your Constitution will make that possible? How are you going to craft a document that makes room for people who may not agree with your vision of the good life? How are you going to include all the people on the left and the right, the religious and the secular, the progressive and the conservative, the vegans and the meat eaters, the crossfitters and the couch potatoes, the Michigan State fans, all the different diversities that we have in our country, some humorous, some quite serious, such that they're going to buy in to a common constitution? How many levels of government are you going to have? And how are you going to divide power between them? How do you give government enough power to do what governments are supposed to do without giving it too much so that it's going to intrude on your rights? And what are governments supposed to do anyway? Are the libertarians right about the limited nature of government? Or do we need a more active Sweden-like government that provides more things for us so that we're taken care of throughout our lives? Who's going to decide that? How are you going to craft a common document to get people's buy-in on those questions? And perhaps most tricky, are people who agree with your vision of the good life always going to be in power? How do you give them the right tools to advance that vision while knowing that those same tools will be used by others who disagree with your vision when they get in power? And with my own students at Calvin, there are some folks who really loved when President Obama had a lot of executive power. And then this last November they said, I'm not so sure about that anymore. Right? It could be vice versa. The same powers that President Trump has to get things done, the same power that President Obama. How do you limit that power so you get done what you want done without giving too much power to the other side when they take power? Let me suggest that this is a very, very difficult thing to do. It strikes me as so difficult we should be very wary of thinking we can provide something better than what has already been provided for us. I know we are running out of time, so I had some words here about how the American Constitution does this. I'm going to skip over that. Let me suggest why I think that Mr. Dahl, Professor Dahl's critique is mistaken. A couple of reasons. One is he doesn't give enough credit to how the American Constitution allows itself to change and evolve. But there's another one that's more salient. I'll add parenthetically that it's a lot easier to write a book than try and write something that 54 other people have to agree with and get passed back home, with all due respect, or I say this with no disrespect to Mr. Dahl. The more fundamental reason to question his argument, though, is that his analogies depend on an implicit premise. It would be ridiculous to hold on to political ideas from the 1770s and 80s and 1860s, just like the electricity and medicine from back then, if politics is the same sort of human activity as medicine, science, and aviation. But is politics like that? Yes, we can point to some improvements in our politics. Right? We've caught up with Plato now. We let men and women govern in our affairs. Right? We have moved past racial slavery. We don't try and prohibit alcohol anymore. These are all very good things. But we might think that politics is different in kind because politics is involved with human nature as opposed to mere technology. The advances in medicine and flying, electricity, or technological advances, is human nature such a thing that it gets advanced in that same way, or is it stable? And here I want to quote, as my colleague did, James Madison, in closing. He writes, he is trying to figure out how do we get a government stronger than the Articles of Confederation, but not getting close to the British government that we rebelled against, that we revolted from. He says, the provision for defense must be this, as in all other cases. The defense must be made commensurate to the danger of attack. Ambition must be made to counter ambition. The interest of the man must be connected with the constitutional rights of the place. And he says, it may be a reflection on human nature that such devices should be necessary to control the abuses of government. But what is government itself but the greatest of all reflections on human nature? If men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls in government would be necessary. All right, let me skip to the end and I'll conclude. Madison's claim, and basically the American Constitution's foundation, is that human beings are capable of reflection and choice. We can think for ourselves and decide what's best for us. We're also fallen. We screw things up. You can take that from a religious perspective or not. Both those truths ground our Constitution. The question I would leave you, if you're tempted by the various folks, Professor Dahl and other people who want to start completely over, is do you think those things have changed about human nature? Are we still capable of reflection of choice? Do we still screw things up given a messed up or fallen nature? If you think that those two things are still a stable part of human nature, and if you found the prospect of a new constitutional convention where you would try and put together a system that could win over a majority of your peers given our current polarization and diversity, then I would suggest that it's good for us to reflect on the Constitution. My own view is that despite its flaws and despite its still need to be worked on, it's done a pretty good job in the last 230 years. And it's up to us to think about how it can be used to continue to protect and better protect the concerns that my colleagues raised. Thank you.
Okay, I had some questions to ask, but I think I'm going to open it up to the floor for questions from all. So, are there questions for either one particular panelist or all of the panelists? Professor Moots?
How do we keep this privileged status of religion from being abused? What constitutes abuse? Can you think of any cases where it's been abused? And how do we prevent that? In other words, how does somebody not use this privileged status as a cover?
Do you want to go first? Go for it. Okay. All right. No, that's a fantastic question, and it does in some ways. It does even framing the question like that raises the issue both of when is religion actually religion and when is religion a pretext. I think there are some very. I mean, it may be that some kind of legislative guidelines are helpful for distinguishing between the two. I think many of the distinctions that have been made historically are very kind of commonsensical. You know, for example, was it in Arizona that the Goddess Temple brothel was operating and claiming a religious exemption from anti-prostitution laws? It was something like this, and basically, you know, law enforcement said, come on, that's a sham. That's obviously not the case. It's a pretext. And obviously there's some more challenging kind of fine-grained distinctions about when is something actually religious and when is it not. But I think that those are by far the exception rather than the rule, and at least in most cases, it's been, I'd say, kind of reasonable prudence can sort most of those out. Now, I'm so far ducking the definitional question. If you want to go after that, I'm happy to. But how do you prevent it from being abused? I can think of one other category of potential abuse, which is when someone who is a serious religionist believes that their religion requires them to do things which are harmful in society. And in fact, we were discussing this earlier, which is, what about the people who want to sacrifice their children to Molech, the sun god, right? How do you identify that? And I think that requires some kind of I'm borrowing some language here, even from our discussion, but you need some account of natural law, that is, to distinguish natural moral norms that laws encode for the good of all of society, as opposed to religious laws that are aimed at salvation of some kind. And if someone claims that their religion cuts against the natural law that supports the social order, you've got to prefer the social order.
Yeah, I'd just add that it's not a problem unique to religion. So if you think about the conscious objection laws that people get out of, or serve a different way instead of taking up arms, one can be a secular person and have a conscience reason, right? That's just as possible to abuse that. So I would say it's not a particularly religious problem, it's just a governance problem. Is there any surefire way to prevent the government from mistreating someone? Is there any surefire way to keep citizens from trying to hoodwink the government? No. There's no surefire way, but there are precautions. We can put the burden on the government, right? That if you're going to intrude on someone's liberty, you need to prove that you've got a good reason. And when it comes to the citizens, you have to trust legislatures to try and make those distinctions based on norms. But is there any guarantee they're going to get it right every time? No. But the good thing is, or at least the reality is, that if that's a fatal objection, that's a fatal objection to any form of government. There is no form of government that escapes the possibility that something goes wrong in trying to carry out a policy or
Yeah, I would just add that I think those are good answers, and the courts wrestling with this can be seen in those two tests that I explained. The strict scrutiny test suggests that most people, most of the time, are not going to try to fool the government about their sincerely held religious beliefs, and therefore the government should give a lot of deference when someone says, hey, my religious beliefs prevent me from doing X. The Oregon v. Smith case, the rational basis case test, tends to err on the other side, saying, look, some people kind of take advantage of religion, and in that case you kind of sense that some of the justices didn't believe that this peyote use was really a serious thing, and therefore it shouldn't be a basis for ignoring drug laws or their employment contract. So those two tests are kind of wrestling with this question in terms of what should we privilege? Should we assume most people most of the time are acting in good conscience regarding religious belief, or should we have a test that allows the government to call foul more often than not? And there's not an easy solution, as they've suggested, but I think they've provided some good ways to think about it.
Other questions? In the back?
Thank you all for speaking, by the way, and for being here tonight. I just have a question specifically for the first two speakers, Darren and Jesse. Since we are a business school, many of us are aspiring to be hopefully one day business owners. Since the government gives individuals freedom to sit or not participate during the fight, isn't that a freedom of protection? So does it business owners not have this right?
I think that's more.
Not have the right to.
Well, do they not have a freedom of expression? Like in the case we have with the Mullins versus Masterpiece. Do you believe that business owners should be given the same freedom of expression as anyone else?
Yeah, I think you can make a good case for that. And I think that's another element that I could have spent some time in terms of this will have implications for what rights do business owners have, right? The Hobby Lobby case that came down was a year or two ago also got into that. Since Hobby Lobby is a for-profit corporation, this was dealing with the contraceptive mandate that Dr. Covington was talking about. In that case, the court ruled the Hobby Lobby does have some rights that, even as a for-profit business. So it'll be interesting to see how that might come into play here. I mean, they're different issues slightly, but it does get to the issue of, do business owners have rights when it's their business? Do they give up those rights when they open the door to the general public? And that's where that tension between public accommodation and, say, free expression or religious freedom comes in. And it's not an all or nothing either way, right? And that's where the court is trying to help navigate this. And that's where I was also kind of the court is kind of a blunt instrument in some of these things. And so that's why I was kind of throwing it back to us as Americans. Can we think thoughtfully and deliberatively about ways where business owners don't have to give up all the rights when they open their doors, but at the same time there's reasonable expectations that they won't discriminate in ways that harm the general public. So yeah, I guess the short answer, yes, I think they do have rights. We're working it out as Americans what those look like in the 21st century.
Your question highlights an important issue, which is, does forming a business, basically, does a business exist solely for the purpose of making a monetary profit? And I'm guessing, if many of you want to go into business, you may, I'm guessing you want to make a profit, but I'm also going to guess that some of you may have other goods in mind that you'd like to pursue with your business. That is, that you'd like to meet a particular need or population that isn't currently being served. Or you may want to rectify a social injustice using the mechanisms of the market to do so. And one of the issues that arises in the types of cases that Professor Guerra was talking about, and arises in some other kinds of cases, is when businesses are formed, they often have these additional purposes. You can see that most obviously in the cases of, say, a halal butcher shop, right? Which is both a butcher, is going to sell meat, is also deeply informed by the Muslim faith of its owners and the population that it serves. Or, I could give other examples. But one of the things I think is important, I think your question draws to the foreground, is when do corporations, and I'm using the term very loosely, but businesses, also need to enjoy rights as individuals do. One of the phrases that we pejoratively hear used in relation to campaign finance reform law is, well, corporations are people too, to say, well, obviously they're not. But at the same time, even framing it in terms of when groups of people get together for purposes of business to accomplish both making money and some other good, be it a religious one or an expressive association to communicate something, then I think we have to take more seriously whether or not corporations are people too in a constitutional sense. And I will say that the memo from the Attorney General on this past Friday specifically names that issue, that the rights of religion obtain to corporations, not just individuals.
Other questions? Okay, go ahead.
That's a good question for a comparativist, which none of us, unfortunately. So the answer is yes. There are. So in the European constitutions, you will see, I think, some religious freedom treatment, but it's not near. I think ours is one of the most robust. The UN Declaration of Human Rights includes freedom of conscience, but how that gets interpreted in different countries is quite different. if you are living in a Muslim country that is, this comes up with the event that Professor Moots is putting on in a little while. If you are not free to convert necessarily in some places, you don't have that freedom to convert from Islam to another religion, or at least it's not robustly protected. So it's going to vary, but the regimes that have robust religious freedom I can't think of one that would be close to what the United States has had. But that's a off-the-hip answer.
I can add a little bit to that.
Thank you.
I'm not a comparativist, and I didn't stay at Holiday Inn last night, but I was just recently at a panel in D.C. where they were talking about this, and you're mentioning the UN Declaration of Human Rights brought to the fore. They were mentioning there's a lot of countries that have signed on to the UN Declaration of Human Rights, which includes freedom of religion, but the diplomat there that was speaking was saying most of them just ignore it. They don't adhere to freedom of religion. And he was calling for the United States, that has a more robust view of this and more robust legal protection of it, to again take a leadership role in the world to hold some of these countries to account on these things. So I don't know if that helps.
I'll add just one small thing, which is many constitutional democracies globally that even have modeled a number of their constitutional provisions on the American Constitution include some mention of God in their Constitution. Specifically, that they often frame some kind of penultimacy piece within their Constitution. In fact, the U.S. Constitution is fairly unique among many constitutional democracies for not doing that. So in one sense, part of at least the link to the kind of the broader point about liberalism is embodied in a lot of other constitutions, even if the specific protections for religion are different and potentially weaker.
All right, I think we have time for one more question, or in the back.
The case in Colorado, do you kind of project out massive case? Where does that leave the country?
Yeah. It's hard to project out, but I'll do it since you asked. I think that if he should win, it's my opinion that the court would be preserving a public space for Americans to continue to work this out. It would signal to local governments and state governments that you can't weaponize the Public Accommodations Law. That it has a good purpose at its core, but it can easily lead to government compulsion of speech and government compulsion of violating one's faith. That's my personal opinion. If the Colorado Civil Rights Commission wins, it does open up the possibilities for local governments or state governments to perhaps target minority populations, however you want to define that, whether it's a religious population or whatnot. And the facts of this case it is a curious question why the Civil Rights Commission gave exemptions in those other cases that I mentioned and didn't give one to him, and one wonders what's going on there, and that seems to be problematic. And so I could see that opening up possibility for some local official that's very zealous on these particular issues to go after. So that's why I think it's important. I think the one way would preserve a public space to let's work this out. You can't just run roughshod over business owners. The other one I fear does give some license to local officials who may not. In some ways it's harder to hold them accountable because they're under the radar a little bit sometimes. So yeah, that'd be my answer to that.
One more. Yeah, go ahead.
Yeah, I have a question. So do you think that we as a society can rely on capitalism and market economy in the absence of government intervention as a key solution to discrimination and racism, or do we need government intervention in the cases like in a Christian bakery, full New York concern?
Yeah, no, I think it's a great question. I think that for the most part, the market can meet those needs. In other words, if someone, for religious reasons or conscience, what have you, doesn't feel that out of a duty, sincerely, they can serve a particular event, right? The issue here isn't serving a particular population. It's just I can't serve a certain events or I won't do certain types of cake. I think the market's pretty good at solving those issues. The couple in question got a cake for their wedding. It didn't It didn't impinge on their ability to celebrate what they felt was really important. And I think 9 times out of 10, the market's really good at providing incentives for people to provide goods and services to all hosts of people. The history of the Public Accommodation Law goes to, one of the original sins of America in terms of racism and entrenched racism, particularly in the South, particularly with laws that prevented the market from doing, one could argue potentially, you never know, that absent the Jim Crow laws, even with pervasive cultural racism, the market might have over time overcome that in terms of providing enough services that people could get along and even flourish. But the law in that case was preventing the market from doing what it does really well. So I would say for the most part, no, you don't need government to step in. There might be cases like in our history in the 1960s where you could make a good case the government did have to kind of pry open the market.
All right, well, thank you all for coming. That's it. Thank you for the panel.